Hey everyone, welcome to this week's edition of Title Scoop. So this week we are continuing our talk on missing persons. Last week we talked a little bit about the basics, what the definition of a missing person was, and this week we're going to go a little bit more into the court process, who can actually ask the court to handle this matter, and then I think next week we will go into really how we got around the due process issue from that Supreme Court case, as well as administration of the estate of an absentee or missing person. So one of the first questions that came to mind for me was who could actually petition the court if they had a missing person? And what I found is pretty much anyone with an interest in the property of the missing person could petition the court, and they could ask the court to appoint someone to basically handle this estate or the property. Now this could be when the person's missing and they just want to make sure the property's being taken care of, or maybe they're trying to sell it. It just kind of depends. Now, some states may require an attorney to be that appointee, and some are okay with whoever the petitioner has requested as long as the court finds that they are someone who could do it. Now, the appointee may be called something different. It might be an appointee. Some states call it a curator, representative, conservator, trustee, and then I think the one I saw was a receiver. So a lot of that's dependent on where the statute falls within all of the laws of your state. So it's just gonna, again, might be a different name depending on your state. Now, the other thing to know about an appointee is their powers are pretty limited, and the court and the statutes are going to limit what they can and can't do. So they don't have full power like other parts of the states where you might have, you might have a trustee or something like that, or you might have an administrator who has a lot of power. These are pretty limited. Now, depending on your state and depending on what the person's doing, they might have to establish a trust fund or a bond. And the reason for that is that really the court wants to protect that person who's missing. They want to protect at least the funds if they're not, if the person's trying to sell. So again, the statutes are going to be really specific as to what they're going to do if we have funds being distributed after a sale of property. Now, at any time when you're doing the procedure to determine someone missing, and you're getting an appointee, the court may say, hey, we should actually administer this estate. Now, usually, well, if for title insurance purposes, we would prefer that they're going to administer after they have declared the person dead, because it's a little bit more clear, but it's not to say that we couldn't do it if someone was missing, as long as the statutes and the facts are sufficient for us to determine that we could actually insure it. Now, if you get to the point where they want to administer the estate, often the states have a separate statute, and again, we're going to go into that next week because these were created due to that Supreme Court case, where you're actually going to declare the person dead. So this might be called a declaration of death. It might be a presumption of death or determination of death. Again, all different names pretty much mean the same thing depending on your state. And if you are asking the court to make this determination, the court's going to want you to prove a few things. Now, they're similar to what a definition of a missing person was, although adding one additional. So if you're trying to declare a person dead, the court is probably going to want you to prove they've been missing from your state for a set amount of time, right? What that time period was, and again, all state dependent. That the disappearance has been continuous and inexplicable. Nobody knows why, and they've never shown back up. There's been no communication during that time period, so that's a really critical one. If there's been communication, at least from what I found, it looks like that time starts over. So again, not always determined in the states, but I would venture a guess that would be the case. And that there was a diligent but unsuccessful search and or inquiry during the time. So we need to have those four things in order for a person to be declared dead or somewhat similar to that. So again, just going to depend on your state statute. Now, I will say one caveat is if it's a military person. There are federal rules as well as usually state rules regarding military. The reason for that is that people will go into battle. They might be determined missing in action. And the laws are pretty specific as to when that can be done, when we can follow those statutes, and what we're going to do with those. So just an FYI, if you have that, it may be under a different statute than a regular absentee or missing person. Now, one just crazy scenario that I found when I was reading through different things is a woman's husband disappeared. He'd been gone for years, and she was asking, what did she do? She couldn't keep up with the mortgage. She didn't really care about the house, and she wasn't sure what she could do. And the advice from one of the attorneys, and I actually was like, well, this is creative, I don't know if it's the best advice, was, well, if they bought the house together and the husband was on the mortgage, presumably she could let it go into foreclosure and then it would be taken care of where that interest would be wiped out. And I thought, again, maybe not the best advice, but clever, because if in fact she had no equity, she didn't care about the property, it might have been an option. Probably not great for her credit, but an option. All right, that's it for this week. If you guys have questions, let me know. Otherwise, we'll see you next week.